Good afternoon, attorney Paul. Good afternoon, classmates. I'm Harold Bisana, but I'd be happy if you call me Hanrui or simply Roy. Excuse me. Today, I will be reporting some of the provisions under the Bill of Rights of the Constitution. My first topic of my report is about non-impairment of contracts provided under Article 3, Section 10 of the 1987 Constitution. The non-impairment clause renders null and void a law which changes the terms of a legal contract between parties, either in the time or mode of performance, or imposes new conditions or dispenses with those express or authorizes for its satisfaction something different from that provided in terms. The non-impairment clause is a constitutional provision that protects contracts from being modified by subsequent laws. It is found in the Constitution and it is designed to promote fairness and justice, as well as to encourage confidence in the contractual agreements. In essence, the non-impairment clause means that once a contract has been entered into, the terms of that contract cannot be changed by a subsequent law. If a law is passed that changes the terms of a contract, that law would be null and void because it impairs the obligations of the contract. For example, if you sign a lease agreement to rent a property for a certain amount of money, and then a law was passed that increased that rent, that law would be null and void because it impairs the obligations of your lease agreement. But it should be noted that while the non impairment clause generally protects contracts from subsequent laws, there are exceptions. For instance, police power legislation, which is enacted to promote public welfare, is applicable not only to future contracts, but equally to those already in existence. However, if such a law unduly impairs contractual obligations, it could potentially be challenged. To fall within the prohibition, the change must not only impair the obligation of existing contract, but the impairment must be substantial. Moreover, the law must effect a change in the rights of the parties with reference to each other, and not with respect to non-parties. A law can be invalidated on the ground of impairment of contracts under certain circumstances. Number one, change in contractual intent. A law that enlarges, abridges, or in any manner changes the intent of the parties to the contract necessarily impairs the contract itself. Such a law cannot be given retroactive effect without violating the constitutional prohibition against the non-impairment of contracts. Second, defect in consent. A contract where consent is given through mistake, violence, intimidation, undue influence, or fraud is voidable. If a law is passed that enforces such a contract, it would potentially be invalidated. And number three, police power legislation. While the non impairment clause generally protects contracts from subsequent laws, there are exceptions. For instance, police power legislation, which is enacted to promote public welfare, is applicable not only to future contracts but equally to those already in existence. However, if such a law unduly impairs contractual obligations, it could potentially be challenged. Limitations on the impairment clause. The legislature cannot bargain away the police power through the medium of a contract. Neither may private parties fetter the legislative authority by contracting on matters that are essentially within the power of the law-making body. Like the police power, the other inherent powers may validly limit the impairment clause. This is in a case of City of San Pablo versus Judge Reyes and Meralco. Rights of the accused. The second topic of my report is about the rights of the accused. Under Article 3, the following are the rights of the accused in a criminal prosecution under the Constitution. Number one, the right to due process. Second, the right to presumption of innocence. Third, the right to be heard. Fourth, the right to assistance of counsel. Fifth, the right to be informed of the cause and nature of accusation against him. Sixth, the right to speedy, impartial, and public trial. Seven, the right to confrontation. Eight, the right to compulsory process. Nine, the right against trial in absentia. And lastly, the right to bail. Criminal due process. Due process in criminal proceedings is a constitutional right that ensures fair treatment through the normal judicial system. Here are the key elements of due process in criminal proceedings. Number one, the accused has been heard in a court of competent jurisdiction. Second, the accused is proceeded against under the orderly process of law. Third, the accused has been given notice and an opportunity to be heard. And lastly, the fourth one, the judgment awarded within the authority of a constitutional law. These principles are enshrined in the Philippine Constitution and guarantee every individual the right to a fair hearing and an opportunity to defend themselves. This applies not only in criminal cases but also in administrative and institutional settings. The Supreme Court of the Philippines has interpreted the Due Process Clause to include a number of rights, including the right to a fair trial, the right to be free from unreasonable searches and seizures, the right to be free from self incrimination, and the right to be presumed innocent, innocent until proven guilty. What is bail? Um, Bail is the security given for the release of a person in custody of the law, furnished by him or a bondsman to guarantee his appearance before any court as required under the conditions herein specified. This can be found in the Rules of Court, particularly in Rule 114, Section 1. The right to bail is a constitutional right provided for under the 1987 Constitution. Here are the key elements. These elements are primarily dictated by the rules of court and relevant jurisprudence. I'm sorry. Bail may either be a matter of right or a matter of discretion as provided in the Rules of Court, Rule 114, Sections 4 and 5. Generally, bail is a matter of right before conviction, except in cases where the offense is punishable by life imprisonment or death, where evidence of guilt is strong. When bail is a matter of right, bail is a matter of right under the following cases. Number one, all criminal cases within the competence of the Metropolitan Trial Court, the Municipal Trial Court, or the Municipal Circuit Trial Court, because these courts have no jurisdiction to try capital offenses or offenses punishable by reclusion perpetua or life imprisonment. Second, prior to conviction by the regional trial court for any offense not punishable by death, reclusion perpetua, or life imprisonment. And lastly, the third one, prior to conviction by the regional trial court for an offense punishable by death, reclusion perpetua, or life imprisonment when evidence of guilt is not strong. This is found in the Constitution, Article 3, Section 13. And also on the case of Enrile versus Sandigan Bayan under GR 213847. Now, how about when bail is a matter of discretion? The right to bail shall not be impaired even when the privilege of the writ of habeas corpus is suspended. Bail is a matter of discretion under the following cases. Number one, upon conviction by the regional trial court of an offense not punishable by death, reclusion perpetua, or life imprisonment. And second, if the RTC has imposed a penalty of imprisonment exceeding 6 years, provided none of the circumstances enumerated under paragraph 3 of section 5 rule 114 is present as follows. A. That he is a recidivist, quasi-recidivist, or habitual delinquent, or has committed the crime aggravated by the circumstances of reiteration. Second, letter B, that he has previously escaped from legal confinement, evaded sentence, or violated the conditions of his bail without valid justification. Third, that he committed the offense while under probation, parole, or conditional pardon, that the circumstances of his case indicate the probability of flight if released on bail, or that there is undue risk that he may commit another crime during the pendency of the appeal. Again, this can be found under Enrile versus Sandigan Bayan. Excessive bail shall not be required. The Constitution also prohibits the requirement of excessive bail. And lastly, bail for humanitarian reasons. In some cases, bail can be granted on humanitarian grounds. However, this is not a matter of right and is subject to the discretion of the court. When shall bail be denied? Bail shall be denied in the following circumstances. Number one, prior to the conviction by the RTC of an offense punishable by death, reclusion perpetua, or life imprisonment, and the evidence of guilt is strong. Second, after conviction by the RTC of an offense punishable by death, reclusion perpetua, or life imprisonment. And third, after conviction by the RTC of an offense not punishable by death, reclusion perpetua, or life imprisonment, and the presence of bail denying circumstances. This can be read on the Rules of Court, Section 5 of Rule 114. Presumption of innocence. The right to presumption of innocence is a fundamental principle in the Philippine legal system and is enshrined in the 1987 Constitution. Here's what it entails. What does the right of presumption of innocence mean? The right means that in a criminal case, the accused is entitled to an acquittal unless his guilt is shown beyond reasonable doubt. Proof beyond reasonable doubt does not mean such a degree of proof, excluding possibility of error, produces absolute certainty. Moral certainty only is required, or that degree of proof which produces conviction in an unprejudiced mind. This is provided by the Rules of Court, Section 2, Rule 133. The rationale for the presumption of innocence is to maintain a balance between the machineries of the state and the accused. However, there are exceptions to the constitutional presumption of innocence. For example, an accountable public officer who fails to account for funds or property that should be in his custody is presumed to be guilty of malversation of public funds. Similarly, persons in possession of recently stolen goods are presumed guilty of the offense in connection with the goods. In cases of self defense, the person who invokes the self defense is presumed guilty, and the burden of proving the elements of self defense is incumbent upon the accused. This right is a cornerstone of fair trials and due process, ensuring that individuals are not unjustly convicted. Burden to overcome the presumption of innocence lies with the prosecution. This is a fundamental principle in criminal law, not just in the Philippines but globally. Here's what it entails. The prosecution must prove every element of the offense beyond reasonable doubt. This means that the prosecution must establish the guilt of the accused with moral certainty. This proof beyond reasonable doubt. This is the highest standard of proof that must be met in any trial. The prosecution's case must rise on its own merits, not merely on relative strength as against that of the defense. Failure to meet the burden. If the prosecution fails to discharge its burden, acquittal must follow as a matter of course. If there is a reasonable doubt, an accused person must be given the benefit of the doubt and clearly uncleared because the state's burden of proof has not been met. This principle ensures that individuals are not unjustly convicted and maintains the integrity of the legal process. In People versus Hilario, this case involves Hilario and Guadayo, who were charged with illegal sale and possession of dangerous drugs under Republic Act number 9165. The, the main issue here was whether Hilario and Guadayo were guilty of the charges against them. The Supreme Court acquitted both the accused uh, on charge of illegal sale of dangerous for failure of the prosecution to prove the, the guilt beyond reasonable doubt. Reasonable doubt. What is reasonable doubt? The term reasonable doubt refers to a standard of proof that must be surpassed by the prosecution. The prosecution is tasked with proving the defendant's guilt beyond a reasonable doubt. This means that the evidence presented at trial must leave no other reasonable explanation that could come from the evidence. Excuse me. If the judge has a reasonable doubt about the defendant's guilt, they should pronounce the defendant not guilty. In other words, if there is insufficient evidence that prevents a judge from convicting a defendant of a crime in court, it is considered a reasonable doubt. This principle is a cornerstone of many legal systems, and it is designed to prevent innocent people from being wrongly convicted. It underscores the concept that the defendant is presumed innocent until proven guilty. It's important to note that beyond a reasonable doubt is the highest standard of proof that must be met in any trial. In civil litigation, the standard of proof is typically lower. A preponderance of the evidence or clear and convincing evidence rather than beyond a reasonable doubt. Equipoise rule and pro reo principle. These principles are designed to ensure fairness and justice in legal proceedings, particularly when there's uncertainty or doubt. They uphold the presumption of innocence and protect the rights of the accused or the employee. In equipoise rule, this rule is often applied in labor and criminal cases. When the evidence presented by both parties is in equipoise, meaning it's evenly balanced. The scales of justice are tilted in favor of the employee or the accused. This rule is based on the policy of the state to afford greater protection to labor and the presumption of innocence in criminal cases. Even if both parties have presented substantial evidence to support their allegations, the equipoise rule dictates that the scales of justice must be tilted in favor of labor or the accused. In pro reo principle, or otherwise known as in dubio pro reo, this is a Latin term which literally means in cases of doubt, then for the accused, or in layman's term, innocent until proven guilty. This principle is highly used in criminal proceedings. Any judge of any court should apply this principle in making decisions, especially for criminal proceedings. The principle of in dubio pro reo is very strict in its sense to give justice to the accused as much as it gives the offended party. This principle is in consonance with the constitutional guarantee that the accused ought to be presumed innocent until and unless his guilt is established beyond reasonable doubt. The right to be heard. The right to be heard is the most basic principle of due process. It is a settled rule that there is no denial of due process when a party has been given an opportunity to be heard and to present his case. There is only denial of due process when there is total absence or lack of opportunity to be heard or to have one's day in court. Um, The constitutional right to be heard is enshrined in the 1987 Constitution. It is a fundamental right to due process and is integral to the administration of justice. According to the 1987 Constitution of the Philippines, in all criminal prosecutions, the accused shall be presumed innocent until the contrary is proved, and shall enjoy the right to be heard by himself and counsel, to be informed of the nature and cause of the accusation against him, to have a speedy, impartial, and public trial, to meet the witnesses face to face, and to have compulsory process to secure the attendance of witnesses and the production of evidence in his behalf. This means that an individual has the right to present their case in court provided the evidence and challenge the evidence presented by the other side. It also includes the right to legal representation, the right to a fair and public hearing, the right to meet the witnesses face to face, and the right to have compulsory process to secure the attendance of witnesses and production of evidence uh, on their behalf. The opportunity to be heard is an intrinsic part of the constitutional right to due process. Thus, in criminal cases, cases against the accused are immediately dismissed upon death, since the accused can no longer participate in all aspects of the proceedings. These rights are designed to ensure that justice is served and that what is this? And that every individual receives a fair trial. They uphold the principle of innocent until proven guilty and protect the rights of the accused. The extent of the accused's right to counsel. Under the 1987 Constitution, the accused's right to counsel is extensive. The right covers the period beginning from custodial investigation well into the rendition of judgment and even an appeal. Article 3 of the Constitution provides this right to an accused not only during trial but even before an information is filed. Question: what are the rights to counsel of a defendant during trial? As a general rule, the right to counsel during the criminal proceeding is not subject to waiver, except if the accused is allowed by the court to defend himself. This is under the Rules of Court, Section 6, Rule 116, subject to Section 34 of Rule 138 of the Rules of Court. The right to be informed of the nature and cause of accusation. What is the rationale behind this constitutional guarantee are the following: to furnish the accused with the description of the charge against him, as well enable him to make his defense. Second, to avail himself of his conviction or acquittal for protection against a further prosecution for the same cause. And number three, to inform the court of the facts alleged so that it may decide whether they are sufficient in law to support a conviction if one should be had. Right to speedy, impartial, and public trial. The right to speedy trial means one free from vexatious, capricious, and oppressive delays, its salutary objective being to assure that an innocent person may be free from the anxiety and expense of a court litigation, or if otherwise, of having his guilt determined within the shortest possible time compatible with the presentation and consideration of whatever legitimate defense he may interpose. Question. May the right to a speedy trial be waived? Yes. The answer is yes. The right to a speedy trial may be waived, but waiver is not to be inferred from mere failure of the accused to urge the trial of the case. Such waiver or abandonment may be presumed only when the postponement of the trial has been sought and obtained by the accused himself or by his attorney. The presumption is always against the waiver of constitutionally protected rights. The remedy in the event of a non observance of this right is by habeas corpus if the accused were restrained of his liberty or by certiorari prohibition or mandamus for the final dismissal of the case. Right of con- confrontation. Constitutional confrontation requirements have been held to have two purposes. First and primarily, to secure the opportunity of cross examination, and secondarily, to obtain the benefit of the moral impact of the courtroom atmosphere as it affects the witnesses demeanor. Is the right available to the defendant as a matter of right during preliminary investigation? No. An accused is not entitled as a matter of right to be present during the preliminary examination, nor to cross-examine the witness presented against him before his arrest. The purpose of said examination being merely to determine whether or not there is sufficient reason to issue a warrant of arrest. A preliminary investigation is generally a proceeding ex parte in which the person charged has no right to participate or be present. This can be read in the case of Marinas versus Siochi and GR number L 25707. Right to compulsory process. The right to compulsory process of an accused pertains to number one, his right to secure the attendance of witnesses, subpoena ad testificandum, and number two, his right to the production of evidence in his behalf, subpoena juris tecum. This is under Article 3, Section 14, Paragraph 2 of the Constitution. Requisites of right to compulsory process. The following are the requisites of right to compulsory process. Number one, that the evidence is really material. Number two, that the accused is guilty of no neglect in previously obtaining attendance of said witness. Number three, that the evidence will be available at the time desired. And lastly, number four, that no similar evidence could be obtained. Right to speedy trial and disposition of cases. All persons shall have the right to a speedy disposition of their cases before all judicial, quasi-judicial, or administrative bodies. Question. When is the right to speedy disposition violated? When the answer is when the proceedings are attended by vexatious, capricious, and oppressive delays, or even without cause or justifiable motive, a long period of time is allowed to elapse without the party having his case tried. Difference of right to speedy disposition of cases from the right to speedy trial. While the rationale for both rights is the same, the right to speedy trial may only be invoked in criminal prosecutions against courts of law. The right to speedy disposition of cases, however, may be invoked before any tribunal, whether judicial or quasi judicial. What is important is that the accused may already be prejudiced by the proceeding for the right to speedy disposition of cases to be invoked. To whom does the right to speedy disposition of cases extend? A person's right to the speedy disposition of his case is not limited to the accused in criminal proceedings, but extends to all parties in all cases, be it civil or administrative in nature, as well as all proceedings, either judicial or quasi-judicial. In this accord, any party to a case may demand expeditious action to all officials who are tasked with the administration of justice. The right to a speedy disposition of cases extends to all persons. This right is enshrined in Section 16, Article 3 of the Philippine Constitution. It applies to all cases before all judicial, quasi-judicial, or administrative bodies. This right aims to protect persons from intentionally long and drawn-out detention and imprisonment. It is designed to prevent the oppression of the citizen by holding criminal prosecution suspended over him for an indefinite time, and to prevent delays in the administration of justice by mandating the courts to proceed with reasonable dispatch in the trial of criminal cases. Please note that there is a distinction between the right to a speedy trial and the right to a speedy disposition. The right to a speedy trial applies only to criminal cases, while the right to a speedy disposition applies to all cases. Right against self incrimination. The basis of right against self incrimination is Article 3, Section 17, which states that no person shall be compelled to be a witness against himself. The right against self incrimination is a fundamental principle in many legal systems, including the Philippines. Here's a brief explanation. Excuse me. The right against self incrimination is accorded to every person who gives evidence, whether voluntarily or under compulsion of subpoena in any civil, criminal, or administrative proceeding. The right is not to be compelled to be a witness against oneself. It secures to a witness, whether he be a party or not, the right to refuse to answer any particular incriminatory question. For example, one, the answer to which has a tendency to incriminate him for some crime. The right against self incrimination has two aspects. One, the right to refuse to take the witness stand, which is available only to an accused in a criminal case, and the right to refuse to answer an incriminatory question, which is available to both the accused and any witness. The privilege against self incrimination parries the general obligation to provide testimony under oath when called upon, but it also applies in police interrogations. In all cases, the privilege must be supported by a reasonable fear that a response will be incriminatory. This right is based on the grounds of public policy and humanity. Of policy, because if the party were required to testify, it would place the witness under the strongest temptation to commit the crime of perjury. And of humanity, because it would prevent the extorting of confessions by duress. Scope of the right against self-incrimination. The prohibition against compelling a man in a criminal court to be a witness against himself is a prohibition against the use of physical or moral compulsion in order to extort communications from him. It is not meant to exclude the accused body as evidence when it may be material. The prohibition is simply a prohibition against any process intended to extract from the defendant's own lips, against his will, an admission of his guilt. The right against self incrimination in Philippine law is quite comprehensive. Here are some key points. The right against self incrimination is accorded to every person who gives evidence, whether voluntary or under compulsion of subpoena, in any civil, criminal, or administrative proceedings. In custodial inclusion of custodial investigation, any person under investigation for the commission of an offense has the right to be informed of the right to remain silent and to have a competent and independent counsel, preferably of their own choice. The right against self-incrimination has two aspects. No, as I have mentioned a while ago, the right to refuse to take the witness stand, which is available only to an accused in criminal case, the right to refuse to answer an incriminatory question, which is available to both the accused and any witness. Extension to administrative investigations. The right of the accused against self-incrimination is extended in administrative investigations that partake of the nature of or are analogous to criminal proceedings. Also on testimonial compulsions. The right against self-incrimination covers testimonial compulsion only and the compulsion to produce real or physical evidence using the body of the witness of the accused. Cases where may the right against self-incrimination be invoked. The right against self-incrimination may be invoked in the following cases. 1. Criminal cases. 2. Civil actions. 3. Administrative cases or proceedings. 4. In a proceeding that can result in the loss of the privilege to practice a profession. And number 5. In a proceeding which may result in forfeiture of property. The kind of protection the right against self-incrimination guarantee depends on the kind of proceeding. The rules are as follows. If it is a criminal case, the accused can refuse to take the witness stand. If it is an administrative case, the parties thereto can only refuse to answer if incriminating questions are propounded. If it is an administrative case that partake of the nature of a criminal proceeding, the parties can altogether refuse to take the witness stand. If it is a civil action, the parties can only refuse to answer if incriminating questions are propounded. If it is a civil action that is criminal in nature, the parties thereto can altogether decline to take the witness stand. To discuss further, the right against self-incrimination is accorded to every person who gives evidence, whether voluntary or under compulsion of subpoena, in any civil, criminal, or administrative proceeding. It secures to a witness, whether he be a party or not, the right to refuse to answer any particular incriminatory question. For example, one the answer to which he has a tendency to incriminate him for some crime. Also, in custodial investigation, any person under investigation for the commission of an offense shall have the right to be informed of his right to remain silent and to have competent and independent counsel, preferably of his own choice. Any confession or admission obtained in violation of this shall be inadmissible in evidence against him. So the right to self-incrimination covers testimonial compulsion only and the compulsion to produce real or physical evidence using the body of the accused. It applies to commutative testimony and not mechanical testimony. There are also exceptions. No, the right cannot be invoked when the state has the rights to inspect documents under its police power, such as documents of corporations. Uh, the right against self-incrimination can be invoked in all proceedings instituted by the government. Right against double jeopardy. The right against double jeopardy is enshrined in the 1987 Philippine Constitution. Specifically, Section 21, Article 3 of the Constitution states that no person shall be twice put in jeopardy of punishment for the same offense. This means that a person cannot be tried or punished twice for the same crime. If an act is punished by a law and an ordinance, conviction or acquittal under either shall constitute a bar to another prosecution for the same act. The constitutional right against double jeopardy protects one against a second or later prosecution for the same offense, and that when the subsequent information charges another and different offense, although arising from the same act or set of acts, there is no prohibited double jeopardy. To raise the defense of jeopardy, the following requisites must be present. First, number one, a first jeopardy must have attached prior to the second. The first jeopardy must have been validly terminated, and the second jeopardy must be for the same offense as that in the first. The provision is a fundamental safeguard in criminal law, ensuring that individuals are not subjected to multiple prosecutions for the same offense, which could otherwise lead to abuse of power by the state. It is a reflection of the principle that the state has a single opportunity to prosecute an accused person to avert potential abuse of state power. It also respects the finality of the judicial process and protects individuals from the emotional, financial, and social uh, consequences of successive prosecution. What is double jeopardy? Double jeopardy is when an accused is acquitted or convicted, or the case against him is dismissed or otherwise terminated without his express consent by a court of competent jurisdiction upon a valid complaint or information, or when a formal charge sufficient in form and substance to sustain a conviction, and after the accused had pleaded to the charge, the conviction or acquittal of the accused or the dismissal of the case shall be a bar to another prosecution for the same offense. This is provided in the Rules of Court, Section 7, Rule 117. The principle of double jeopardy prevents an individual from being tried or punished more than once for the same offense. For double jeopardy to apply, the following requisites must be met: valid complaint or information filed before a competent court to which the defendant has pleaded and defendant was previously acquitted or convicted, or the case is dismissed or otherwise terminated without his express consent. First, jeopardy must be attached. So this means that the first trial must have begun. A trial begins when the defendant is formally indicted and enters a plea. And the first jeopardy must have terminated. The first jeopardy must have ended in some way. This could be through an acquittal, a conviction, or the case being dismissed or otherwise terminated without the defendant's express consent. The limitations to the right against double jeopardy. Dismissal with express consent or upon motion of the accused does not result in double jeopardy. This is because such consent is considered as a valid waiver of his right against double jeopardy. Except the following: dismissal is based on insufficiency of evidence, demurrer to evidence, or denial of the right to speedy trial. This can be found in Philippine Savings Bank versus Bermoy. And second, to reconsider a judgment of acquittal places the accused twice in jeopardy of being punished for the crime of which he has already been absolved. However, there is also an exception when the court that absolved the accused gravely abused its discretion, resulting in loss of jurisdiction, or when a mistrial has occurred. In any such cases, the state may assail the decision by special civil action of certiorari under Rule 65. The following are the limitations to the right against double jeopardy. An acquittal is final and unappealable on the ground of double jeopardy, whether it happens in the trial court level or before the Court of Appeals. Only when there is a finding of a sham trial that the doctrine of double jeopardy is inapplicable because the people, as represented by the prosecution, were denied due process. Doctrine of supervening event. The accused may still be prosecuted. It allows the prosecution for another offense if subsequent development changes the character of the first indictment under which he may have already been charged or convicted. And lastly, inseparable offenses. Where one offense is inseparable from another and proceeds from the same act, they cannot be the subject of separate prosecution. The doctrine of supervening event in double jeopardy is where the first prosecution, a new fact supervenes for which the defendant is responsible, which changes the character of the offense and together with the facts existing at the time constitutes a new and distinct offense. The accused cannot be said in second jeopardy if indicted for the new offense. People versus Manulong, GR number L-2288. For instance, the rules of court provides three instances where an accused may still be subsequently charged with an offense which necessarily includes the offense charged in the former complaint, despite a previous conviction. That is Rule 117, Section 7 of the Rules of Court. Number one, the graver offense developed due to supervening facts arising from the same act or omission constituting the former charge. Second, the facts constituting the graver charge became known or were discovered only after the plea was entered in the former complaint or information, and the plea of guilty to the lesser offense was made without the consent of the prosecutor and of the offended party except as provided in Section 1F of Rule 116. In other words, this doctrine allows for the possibility of a new charge or an amendment of a charge when new facts come to light that change the nature of the offense without placing the accused in double jeopardy. Kinds of ex post facto laws. One, laws which makes an act criminal which was not so before its passage. Second, laws which aggravate the penalty of a crime committed before its passage. A third, laws which inflict a greater or more severe penalty for the same offense. Laws which alter the legal rules of evidence and allowing the receipt of less or different testimony than what the law required at the time of commission in order to convict accused. Laws which assume to regulate civil rights and remedies only, but in effect imposes a penalty of deprivation of right for something which when done was lawful, and laws which deprive the accused of some lawful protection to which he had been entitled, such as protection of a former conviction or acquittal or a proclamation of amnesty. The term ex post facto is Latin for from a thing done afterward. In the context of law, an ex post facto law is a law that retroactively changes the legal consequences or status of actions that were committed before the enactment of the law. Under the 1987 Philippine Constitution, the enactment of ex post facto laws is explicitly prohibited. This is stated in Article 3, Section 22. The provision reads, no ex post facto law or bill of attainder shall be enacted. This prohibition of ex post facto laws is a fundamental aspect of the rule of law, ensuring that individuals have fair warning of the conduct that is deemed criminal and the consequences thereof. It also prevents the government from punishing individuals retroactively for actions that were legal at the time they were committed. Scope of applicability of the prohibition on ex post facto law. The prohibition on ex post facto law applies only to criminal or penal matters and not to laws which concern civil matters or proceedings generally or which affects or regulates civil or private rights. It also applies to criminal procedural law prejudicial to the accused. Ex post facto laws, unless they are favorable to the defendant, are prohibited in this jurisdiction. Bill of Attainder. A bill of attainder is a legislative act that inflicts punishment without trial. This is a case of Cummings versus Missouri. In more modern terms, a bill of attainder is essentially a usurpation of judicial power by a legislative body. It envisages and effects the imposition of a penalty, the deprivation of life or liberty or property, not by the ordinary processes of judicial trial, but by legislative fiat. Bureau of Customs Employees Association versus Teves in GR number 181704. Bill of Attainder is also an ex post facto law. As explained by the Supreme Court, it is not enough that the statute specify persons or groups in order that it may fall within the ambit of the prohibition against bills of attainder. It is also necessary that it must apply retroactively and reach past conduct. This requirement follows from the nature of a bill of attainder as a legislative adjudication of guilt. Thus, if a statute is a bill of attainder, it is also an ex post facto law. But if it is not an ex post facto law, the reasons that establish that is not are persuasive that it cannot be a bill of attainder. People versus Ferrer. This is the last and final topic of my report, which is about the right against excessive fines and cruel and inhumane punishment. Fine considered excessive. For a penalty to be considered obnoxious to the Constitution, it needs to be more than merely being harsh, excessive, out of proportion, or severe. To come under the prohibition, the penalty must be flagrantly and plainly oppressive or so disproportionate to the offense committed as to shock the moral sense of all reasonable persons as to what is right and proper under the circumstances. Republic versus N. de la Mercedes and Sons Incorporated, GR number 201501. The 1987 Constitution, under Article 3, Section 19, Paragraph 1, explicitly states that excessive fines shall not be imposed, nor cruel, degrading, or inhuman punishment inflicted. This provision is designed to protect individuals from disproportionate penalties and to uphold the principle of justice. The prohibition against excessive fines is rooted in the broader principle of proportionality, which requires that the punishment for a crime should not be more severe than the crime itself. This principle is a fundamental aspect of the rule of law and is essential for ensuring fairness and justice in the legal system. It is important to note that while the Constitution prohibits excessive fines, it does not provide a specific threshold or formula for determining when a fine is considered excessive. This is typically left to the discretion of the courts, which interpret and apply the law in accordance with established legal principles and precedents. The prohibition of cruel and unusual punishment is generally aimed at the form or character of the punishment rather than its severity in respect of duration or amount, and applies to punishments which public sentiment has regarded as cruel or obsolete. For instance, those inflicted at the whipping post or in the pillory, burning at the stake, breaking on the wheel, disemboweling, and the like. Fine and imprisonment would not thus be within the prohibition. It takes more than merely being harsh, excessive, out of proportion, or severe for a penalty to be obnoxious to the Constitution. The fact that the punishment authorized by the statute is severe does not make it cruel and unusual. In Corpus versus People, GR number 180016. Here are some key points. The Constitution prohibits the imposition of excessive fines nor cruel, degrading, or inhuman punishment. This includes the employment of physical, psychological, or degrading punishment against any prisoner or detainee. The use of substandard or inadequate penal facilities under subhuman condition is also prohibited. Cruel, inhuman, and degrading punishment involves causing suffering, gross humiliation, or debasement to a person in custody. Punishment is considered cruel and unusual when the penalties imposed are inhuman, barbarous, and shocking to the conscience. Penalties like fines or imprisonment may be considered cruel, degrading, or inhuman when they are flagrantly and plainly oppressive and wholly disproportionate to the nature of the offense. The Constitution prohibits certain acts as cruel and unusual punishment. For instance, no law may be passed that will mandate the looping of the male member of a rapist or the severing of the hand of a murderer or the legs of a kidnapper. Neither may courts impose any sentence prescribing such acts. Justice Brennan's fourfold standards are used to determine if a punishment is cruel, degrading, and inhuman. These standards consider human dignity, arbitrariness and excessiveness, purpose, and communal acceptance. The Brennan test is a fourfold standard used to determine if a punishment is cruel, degrading, and inhuman. It was proposed by Justice Brennan and is used in the context of the 1987 Philippine Constitution. The four standards of the Brennan test are human dignity. This standard assesses whether the punishment respects the inherent dignity of the human person. Second, arbitrariness and excessiveness. This standard examines whether the punishment is arbitrary or excessive in relation to the crime committed. Third is purpose. This standard evaluates the purpose of the punishment and whether it serves a legitimate penal aim. And lastly, communal acceptance. This standard considers whether the punishment is accepted by the community or society at large. The Brennan test is applied to various cases to determine if the punishment being imposed is cruel, degrading, and inhuman. For example, it has been applied to House Bill Number 1 in the Philippines, which proposes the reimposition of the death penalty. The test helps ensure that punishment align with evolving standards of decency and respect for human dignity. Th- This ends my report for today, and I would like to thank my professor, Attorney Polito, for his patience in listening to our reports and to my classmates as well for their participation of this activity today. Thank you.